Sitting and watching a known crack house provides all kinds of information and opportunity for police officers. This principle is as true in Miami as it is in Maine, and it certainly proved true on the north side of Minneapolis on a late autumn evening in 1989. Two patrol officers were busying themselves with nothing in particular when they watched a person leave a 12-unit apartment complex, well known for drug trafficking, who walked down the street towards their well-marked cruiser. Amusingly, when this person seemed to recognize their vehicle and made brief eye contact with one of the officers, he chose that exact moment to walk in the exact opposite direction. It wasn't a good look. When he disappeared down an alleyway next to the apartment complex he had just left, it really didn't look any better. The officers decided now that they had better take a look. They pulled their cruiser into the alleyway and told their suspect to stop moving. In the darkness of the alley, near the location of a crack house, and after the suspect gave every impression that he wanted to avoid their presence, the officers thought a frisk was a good idea. It was. Though the officers did not find a weapon on their suspect, later identified as Tim Dickerson, the frisking officer became interested in a small lump of something in Dickerson's nylon jacket pocket. The officer knew it wasn't a weapon right off, but he also knew it wasn't something good either. While sliding the lump back and forth in his fingers, it came to him. He was feeling crack cocaine packaged in cellophane. The officer removed the item from Dickerson's pocket, and bingo, he was correct. The officers placed Dickerson under arrest and transported him away from the scene. Now came the moment for the legal considerations of this brief encounter. In Terry versus Ohio, a 1968 Supreme Court decision and the topic of another FLETC talk, the court established the legal grounds for a Terry frisk. If an officer had reason to suspect a person was armed and dangerous, he or she could put his hands on the suspect's body to search for a weapon. You know, something you don't want shot with, stabbed with, or even hit over the head with. In a later case, Michigan versus Long, the court even found it judicious to expand the zone of where the officer can put his or her hands. In that FLETC talk, you may have learned that it was reasonable for the officers to enter the suspect's vehicle to find easily accessible weapons. But the matter at hand here doesn't result in the discovery of a weapon at all. Tim Dickerson didn't have any weapons on him. The officers knew that he didn't have any weapons on him. He had a small amount of something that turned out to be 1/5 of 1 gram of a controlled substance wrapped in cellophane. So the Supreme Court had to consider something different altogether here. Isn't this situation akin to the plain view doctrine? Under that legal principle, an officer may retrieve obvious evidence of criminal conduct if she or he see it during the normal course of duties. Is there a parallel plain touch doctrine? That is, may an officer retrieve obvious evidence of criminal conduct if she or he touch it during the normal course of duties? The Supreme Court decided that yes, there was a logical parallel to the plain view doctrine. So, too bad for Tim Dickerson, right? Well, not so fast. Let's apply the logic of the Supreme Court to the case at hand. The criminal evidence must be obvious. The court stated it must be immediately apparent to be evidence of a crime. Was this so? Was the crack cocaine immediately apparent to be evidence of a crime when the officer had to continue rolling it back and forth in his fingers to determine what it was? The simple answer is no, it was not immediately apparent. So maybe the end result worked out for Tim Dickerson. The controlled substance the officers discovered was suppressed from evidence as it was discovered outside the legal limits of the frisk. But the court provided more clarity for the frisk search for other officers. The plain touch doctrine exists. That is, officers engaged in a lawful activity, such as frisking a person suspected of being armed and dangerous, and the officer feels something that is immediately apparent to be evidence of criminal activity, he or she may seize that something. Maybe it didn't happen in that manner in this particular case, but the plain touch seizure can happen all over the country today because of these events. You know, you never know what's going to come out of the darkness of a back alley in Minneapolis on a cold autumn evening. It might be a new Fourth Amendment doctrine. I'm John Besselman, and this has been FLETC Talk.